The next matter is People versus Rhonda Ann Moser. File number is 2688FY. Ms. Moser is here with us by Zoom from the jail. Her lawyer, Mr. Tim George, is here with us. Ms. Moser, can you hear me?
Yes, I can.
All right. I saw this when you got arrested and was disappointed. You're charged with possession of methamphetamine as a drug double and operating while intoxicated as a third offense. Operating while intoxicated as a third offense is a felony punishable by up to...
Whoa, let's pause here. Did you catch that? Up to 30 years in prison if the drug double sticks. This is why DWI and drug charges can snowball fast. Audience, what would you do if you faced charges this act? Comment below.
5 years in prison and 6 points and a fine of up to $5,000 and the suspension of your license. You're charged as a second habitual offender, which makes that punishable by up to 7.5 years in prison, and the drug double would make it up to 30 years in prison. So it's not good. I'm here with your lawyer, Mr. Tim George, and Chief Assistant Prosecuting Attorney Joshua Robert. Mr. George indicates you're going to waive the preliminary examination, have the matter bound over to circuit court, and excuse me, and but he wants to address your bond. Is that correct, Mr. George?
That's correct, Your Honor. We have my client executed the written waiver yesterday at the jail. I provided that to the prosecutor. The offer in this case would contemplate a plea to the OWI charge and a reduction of the possession charge to a use and dismissal of the habitual offender notice. My client indicates that she's not currently on probation or parole. I think one of the big concerns that she has is she is currently doing online schooling through the University of Phoenix. If she remains in custody and is not able to get a hold of individuals at that school, I think she's concerned that she's going to lose the ability to continue.
Notice how the defense is using her college enrollment as leverage? Courts sometimes consider education when setting bond, but with a serious felony, public safety usually outweighs academic plans. What do you think? Should school really impact bond decisions?
On with that, the magistrate set the bond amount in $50,000 cash or surety. That's clearly an amount that my client is not able to meet. We would ask the court to consider whether a 10% provision would be appropriate in this case. I did talk to my client about the likelihood that if she were to be released on some type of bond that she would have to comply with pretrial services. She indicates that she's amenable to that. That could include testing, tether, whatever the court would believe would be appropriate under the circumstances. So we would just ask the court for that consideration. And just so Your Honor knows, she did provide me an updated address that's different than what's on the complaint, so I can provide that to the court as well. Thank you.
The address we had was Kalamazoo. Where are you staying, Ms. Moser?
Oxbow Drive.
All right. With who?
Wendy, WP Bontrager. It's my daughter's husband's mother.
With your daughter's mother?
Husband's mother.
Oh. All right. This is charged as a third offense, drinking driving charge. This is a rollover accident. with a .196 blood alcohol level, also methamphetamine. And they had trouble getting you out of the car. You are not in good shape. Your license is also suspended. You also have $536 worth of unpaid fines and costs. Previous driving suspended from 21. I reminded you about it in November of 2025. Disobeying a traffic control device and a speeding ticket. So, Bear, what's your position regarding the defendant's?
So I think this is a case where we do have to worry about the safety of the public. She has 3 prior OWI convictions, 2 in Michigan, 1 in Indiana.
So this is her 4th OUIL?
Yep. The one in
This is critical. 3 prior WIs, plus meth convictions, and here she is again. The prosecution paints a clear pattern of risk to the public. You can almost hear the court thinking, enough is enough. Anyone else shocked she's still at it?
Indiana was in 2021. That's the most recent. In that case, she was also charged with and convicted of methamphetamine. So it looks like she has 2 problems, methamphetamine and alcohol, in both of these cases. And despite the convictions in 2021 and whatever sentence was imposed, she's continued with both of those habits. So we worry about her getting out and the danger she'd pose to the community. So we would ask the court to leave bond where it's at.
Mr. Gibson, do you have input on this?
Is the bond, what is the current bond?
Well, this is
No, this is Mr. George's client.
Oh, okay, I'm sorry.
Yeah, you don't have it. You don't need to.
Is there another one that we need to do?
No, we're on to felonies.
Okay.
At one time, all of the OUIL thirds were just automatically set at $50,000. Can't really do that anymore. But this one, the magistrate felt it was an issue of public safety. She does have a bad driving record. It is her 4th drunk driving conviction. This was a rollover accident. She was suspended.
Interesting point here. Rollover accident, high BAC, suspended license. The judge clearly flags this as a public safety issue. That's why bond reduction is denied. This is a textbook example of how past behavior shapes immediate court decisions.
She pled to driving suspended in front of Judge Pattison on January 21st from November. Apparently he just took care of that. I think she failed to appear. Let me look at that. She got a ticket on July 6th of 2024. She failed to appear in January. No, you can sit, Rhonda. You had that driving suspended from 2004. You'd failed to appear on several different occasions. You didn't deal with it until after you got arrested. So you had an open warrant for your arrest at the time you were arrested. Your license is suspended. It's a 4th drinking driving conviction with a rollover accident and a high blood alcohol level. Also a 2nd or subsequent possession of methamphetamine. You also have $536 worth of previous unpaid fines and costs. So the motion to reduce the bond is denied. You're not working, you're sleeping on your daughter's mother-in-law's couch, and you got some vague college tuition thing, but that doesn't outweigh the public safety issue. So the matter will be bound over to circuit court if it's going to be worked out as a plea, perhaps sooner rather than.
Here comes a harsh reality. College credits or not, living on a couch, it doesn't outweigh public safety. This is a stark reminder. Courts prioritize community risk over personal convenience. Audience, would you have expected the same ruling?
Later, you're going to get credit for all the time you're served, but I'm not going to reduce the bond. All right.
Thank you,
I'll do
Ryan.
an order.
Sir, I only have 56 credits to get my Bachelor of Psychology. So I've been going to college.
That's good.
It's not
Well, you
like
had
I
to
just,
show up for court, you had open warrant for your arrest, you're out rolling your car over the 0.19 blood alcohol level. There's a consequence. All right, Jordan, I got Pablo in the waiting room.
Yeah, I actually just put in the chat, you need a psychologist. Perhaps. I find it ironic that she's studying psychology but can't keep her own life together. I'm not sure I would want her advising others.
And there it is, ironies everywhere. Studying psychology but unable to manage her own life. This is one of those moments where reality feels stranger than fiction. Comment your thoughts. Does education earn leniency, or do patterns of risk override everything?